docket of the Court of Criminal Appeals for the Eastern Section. Today on the panel, we have Judge Camille McMullen from Memphis, Judge Jill Barty Ayers from Clarksville. I'm Kelly Thomas from Maryville. Initially, let me express our thanks to Nick Morgan and Jim Hibner for doing all the many things that have to be done to make this possible so we can actually have court, and thank you very much for that. The time for argument is the same as always, 20 minutes. If you wish to reserve any rebuttal time for the appellant, please let me know when you start your argument. I don't think we have any preliminary matters, so if you would call the case, please.
State of Tennessee versus Rico Cook.
Good morning.
Mr. Hedrick.
Good morning, Your Honor. Josh, excuse me, Josh Hedrick here for the appellant Rico Cook. If I may reserve 2 minutes of my time for rebuttal argument, please. Two, yes, please.
Okay, all right.
If it pleases the court, Mr. Cook's convictions in this matter should be reversed for 2 reasons. First, that it was error to deny the motion to suppress his statement to law enforcement, and second, that it was error to deny the motion to suppress the eyewitness identification. In this case, Mr. Cook was a 15-year-old child who was taken to juvenile detention by his mother. And when his mother took him to juvenile detention and dropped him off, she told them that she did not want her son to be questioned by law enforcement in her absence. He was then met with investigator A.J. Leffler of the Knoxville Police Department, who came to meet him. And the first thing that the investigator did was he took off his uniform shirt to talk with the child in a plain t-shirt. And he asked the child if he was hurt. And he told him, "I can help you, but only if you tell the truth." Excuse me. And Mr. Cook told the investigator that he was worried and he was scared. He was worried about what would happen to himself. He was scared about what some other people would do to his mother and his family. And he was scared that harm would befall his mother and his family. And the investigator told him that he could help him. "I can help you, but not if you keep telling me the story you're telling me. We can save everybody. We can help you." That's what the investigator told him, "but not if you keep telling me this story that you're telling me now." And ultimately, the child made some inculpatory statements. Now, we heard from 2 experts on the matter. The first was Dr. Cutler, who talked to us about risk factors for what they would call false confessions or coerced confessions. And the key risk factors are youth and mental difficulty, mental delays, developmental delays. And we heard from Dr. Kimberly Brown, and Dr. Brown was expert. She's a psychologist from Vanderbilt who did some evaluations and determined that Mr. Cook, who was 15 years old at the time, as a general matter, Dr. Brown explained to us that at that age, our brains, particularly for males, are not fully formed and don't become fully formed till we reach our mid-20s. So he's already at a bit of a disadvantage in terms of his mental acuity and his ability to reason through to, if I do this now, what will the future consequences be? And to work through if-then consequences, long-term consequences of actions and decisions. And Dr. Brown explained, and this is in the transcript, volume 12 at 754, Dr. Brown explained that a boy of his youth, putting aside any mental difficulties, would be particularly vulnerable to promises that someone could help them or protect them, especially promises coming from an authority figure like a police detective. Dr. Brown explained that she, through her work with Mr. Cook, was able to identify that he suffered from significant learning problems. The records and her work with him indicate that he struggled at school. His most recent grade point average for high school was a 0.25. That is a 1/4%, which, without making light of the situation, is abysmal. That's in the record 12, volume 12 at 758. Her IQ testing that she performed on Mr. Cook resulted in him being placed in the 7th percentile, which I know the court's aware of what that means, but just to highlight that, that means if you took 100 children, 93 of those children would be of higher intelligence than Mr. Cook. And his primary difficulty of interest to us is in language and reading. And the reason why that is so important is because that's exactly what we're talking about, is verbal communication and understanding verbal communication. So we know from the Lundy case, the 808 Southwest 2nd at 444, Tennessee Supreme Court case from 1991, that the tests for juvenile admissibility of confessions is essentially a knowing and voluntary test. And we apply the Callahan totality of the circumstances, the factors from the Callahan case. Some of them, I think, are without contest, that he's 15 years old, which is relatively young, that he has limited experience in the criminal justice system. There's no proof in the record at the motion to suppress stage or later in trial that he has a great experience in the criminal justice system or anything to suggest that he's well versed in the way the criminal justice system works. Educationally, he, as we've discussed, did not finish school. He operates on what we're told by the doctor as a 3rd grade level. That is the equivalent of a 9-year-old child. So he may be 15, but mentally he's about 9. He has significant deficits in language and intelligence. And I say this with due respect to him, but he simply can't help these things. And that brings us to the Callahan factor of the capacity to understand. And the reason why I highlight the capacity to understand is the state in its brief points out that his deficits in language are less important because the Miranda warning was read to him. And the issue isn't really whether he read it or whether it was read to him, but does he understand the words? Not does he know the words, right? So when he's told a statement you give will be used against you, I'm certain that he knows what used means, what it means to use something. And I'm certain that he knows what against means. And I'm certain that he knows what you means. But what he doesn't understand, and what we see in the work from the doctor and the evaluations and his deficits in reasoning and ability to understand, is comprehension of what used against you means. How will it be used against you? Will it be brought in at trial? Will it be played for the jury? Will it be something that will be put up against your testimony? What is the use? What does he understand the higher order principles? Can he apply what he's being told to the facts of his case and to what's going on to actually comprehend what's happening? When we say a lawyer will be appointed for you, does he comprehend what that means? Does he have an understanding of these principles? And that's why it doesn't matter necessarily that the rights were read to him. Because the problem is that he has significant difficulties. He has deficits in language. And deficits in language are an inherent problem in understanding and integrating what the Miranda warning is telling him with what that means for his case. What's the consequence of that? If I talk to this detective, what is the consequence of it beyond what he's being told? Because what he's being told the consequence is that the detective will help him, will rescue his family from these concerns he's worried about, and will aid him and aid his family. That's the consequence he's told. And so the question then is, does he have the facility with language and with understanding to recognize that the Miranda warning means that what you're being told by the detective is not really 100% accurate, or at a minimum, not the complete story? That the detective may I'm certain that Detective Leffler will make every effort to keep his family safe, but that's not really the whole story. That's not the effect of making a statement. The effect of making a statement is it's going to be played for the jury in an effort to convict you. And that's not what he's comprehending here. The other Callahan factors, the familiarity with the warning, the mental disorder, I think I've discussed at length, and the absence of a parent. The absence of a parent in this case is particularly challenging, I would suggest to the court, because there was a parent who was involved, who brought her child to juvenile detention, which is different than adult court. Juvenile court's different from adult court. It operates differently. It's got different goals. It feels different. It's not quite as adversarial. And the parent says, "Don't talk to my child. I want to be there if you talk to my child."
Can you expound upon that a little bit more for me? Help me understand. She dropped him off and then left. Could you give me a little bit more context to
Yes, ma'am.
how that?
So it comes out mostly in the motion to suppress. But what had happened was the investigators developed Mr. Cook as a suspect. And there was media attention that they were looking for Rico Cook, right? And so the family saw from the media attention that they were looking for Rico Cook and that they were trying to arrest him, basically. And because they knew they were trying to arrest Mr. Cook, they took him to juvenile detention because that's where they assumed he would go, being 15, and basically took him to the detention center and said, "I think you're trying to arrest my child." And the detention center said, "Yes, actually, there is a warrant for him. We will take him into custody now." And so the mother, she left him because he was placed under arrest. She didn't, just
Understand.
walk away. And so as she was leaving, she had obviously some conversations with him about, what will happen. Will he have a bond? All those kind of things you'd imagine a family member would say. And she told them, he's not to talk to anybody. We're going to get a lawyer. He's not to talk to anybody.
Okay. All right.
And so that was the dropping off. That's why she dropped him off, or how that happened. And so the difficulty for that point is that ultimately this is a question of voluntariness in terms of his ability to understand. And I'd highlight for the court that the biggest concerns we posit are his mental ability, his young age, and the promises in this interrogation, that this interrogation was coercive, not in a, given him the third degree or violent or angry coercion. This was, when the court watches, you'll see that it's a friendly conversation, but it's coercive in the sense that the investigator is promising to bring the child what the child wants, and the child doesn't have the ability to recognize and play through that if I talk to him, what will the real consequence be to me? What will the impact be? And so for that reason, we suggest that the trial court erred in not granting the motion to suppress the confession. We also suggest that the second reason the conviction should be reversed is because the trial court respectfully erred in denying the motion to suppress the eyewitness identification. And on that point, we rely on Biggers and Scarborough, which the citation, Biggers is a United States Supreme Court case, 409 U.S. 188, and Scarborough from 300 Southwest 3rd 717, which I think the parties both agree are the controlling law on the point. When we apply those factors to this case, we see from the proof that the first factor, the opportunity to view the suspect, was very brief. The alleged victim testified that the interaction didn't take very long. During the interaction, he was looking out the window of the car. At one point, he was smoking a cigar. We heard from Dr. Neuschatz, the expert in eyewitness identification, about the impact of weapon focus, which is, Dr. Neuschatz talked about it in terms of the research that had been done into the area. Although I think to some extent it is self-evident that if someone points a gun at you, you're going to look at the gun and not the person. And I think in large part, we should consider the initial statement wherein the alleged victim testified or said to the officers that he didn't know who shot him, that he wasn't able to identify who shot him. That's his statement given at the scene, immediately at the scene. One of the difficulties we have developing in the area of these kind of eyewitness identifications that the court, I think the court may begin to see more and more of, is with the prevalence of social media and people having all of their business on the internet, we see more and more cases where people are looking on social media and trying to find the people that did this. The court will note that this case actually began with a Facebook message thread about the sale of marijuana. People sending messages back and forth and identifying each other through the Facebook that they're getting pictures off of. And so one of the questions is, are you recognizing that person from the incident or from the photo you saw? That's one of the things Dr. Neuschatz talked to us about, was the fact that human memory is not a video recording, but rather a loose collection of information that your brain is storing. And when we think about, do you know what your spouse looks like? Or do you know what your brother looks like or what your mother looks like? Of course, we all would say, absolutely, I know exactly what they look like. And then the question is, well, when did you learn that? Which exposure sealed that in your memory, right? So when you have someone who says, I recognize that man, are they really recognizing that man from the incident? Or are they recognizing that man from later exposure, either by social media or at juvenile court proceedings? We know that there were some juvenile court proceedings, and I say this without meaning humor. It's not difficult to identify the defendant in a juvenile court proceeding because the proceedings are not open to the public. There's me in my suit, and there's a child sitting next to me, and that's the only two people at the table. And so it's not difficult to pick which one is the defendant. It's the one that isn't the lawyer. And the same is true for trial. We also have, as we heard, the deleterious effect that stress has on memory, not just the weapon focus, but the fact that, as Dr. Neuschatz explained to us, we're very complex animals, but we're animals. And when we're faced in a situation where we are put in a survival mode, our brain is focused on surviving and not creating memories and being detailed about the information it's giving. Our brain is hardwired to focus on not dying. And I do not mean that to be humorous, but it's something that we have to consider. So given that we have prior exposures prior to the identification, an initial statement that the witness could not identify, I say witness, or really the alleged victim, could not identify the assailant, and that the degree of attention and the opportunity to view the assailant were both limited. For all of those reasons, we suggest that it was error to deny the motion to suppress the eyewitness identification in this case. If the court please, that is the reasons why we believe that the conviction should be reversed, and that would be our request of the court. Thank you, Your Honors.
Thank you. General Redding.
Good morning. May it please the court, Catherine Redding on behalf of the state. The trial court acted within its discretion when it denied the defendant's motion to suppress his police statement, finding that he voluntarily, knowingly, and intelligently waived his Miranda rights. First, the circumstances surrounding the interrogation support the trial court's finding of a voluntary and knowing waiver. The defendant was only detained for an hour before the interview, and the interview itself only lasted 45 minutes. The defendant was 15 years old, and he was in the 9th grade. Although he did have a learning disability that did cause him to read at a 3rd grade level, a 2012 assessment conducted by his school showed that his scores on their testing were indicative of an average IQ, and that his learning disability wasn't the result of an intellectual disability. The investigator who conducted the interview read the defendant his Miranda warnings, and there's no indication from the defendant that he didn't understand the effect of his waiver, that he was confused, and he didn't ask any questions about the waiver. The defendant was questioned using age-appropriate language. It's apparent from his statements that he understood the questions and that he was able to answer coherently. There's nothing in the record to show that he was threatened or intimidated by the interviewing officer, or that he was panicked or afraid of the officer who conducted the interview. Second, the defendant did have the capacity to understand the Miranda warnings and the consequences of waiver. His reading disability, as defense counsel mentioned, does mean that he had trouble analyzing details and themes in a text. That's what the assessment from his school showed. But as I mentioned, the Miranda warnings were read aloud to him, so there wasn't an issue here of him reading a text. The defendant's statements that he made to Investigator Loeffler show that he did understand the ramifications of waiving his Miranda rights and making a statement, that he understood the ramifications in terms of the court procedures, what would happen in the legal process. He said, I'm going for life. He said that he didn't believe Investigator Loeffler when he said he could help him, and that he was going to go to jail. This indicates the defendant understood what might happen as a result of the interview. And he made statements indicating that not only did he understand what could happen in the court system, he understood what would happen if he would be released after making a statement that there might be implications for him out in the real world. Even if the defendant did have a below average or low IQ, he still had the mental faculties to knowingly and voluntarily waive his Miranda rights. He gave a statement where he discussed his actions before, during, and after the events. He understood the gravity of the situation, as evidenced by the fact that his immediate reaction to the interview was to deny involvement and to place himself far away from this incident. He was able to analyze the information that was conveyed to him by the interviewing officer and alter his version of events, his story of what had happened based on the information that he was hearing. He first denied involvement. Then when he was confronted by the investigating officer, he changed his story. He blamed Christopher Johnson, said he was the one who did it, but still maintained that he wasn't involved. And his final version of events, he admitted that he was involved, but was able to craft a story where he acted in self-defense. So if you look at the defendant's statements, his understanding of the gravity of the situation, this court has found that these kind of factors are indicative of an ability to knowingly and voluntarily waive Miranda rights, even when there is a lower than average IQ. And this change in the defendant's story indicates not only a certain level of sophistication, his immediate reaction and immediate version of events in denying responsibility indicates that he had a plan. He had thought about what he was going to say to law enforcement and was not taken by surprise by the questioning. And finally, if we look at the trial testimony, you see not only was the defendant testified on his own behalf, and he was able to respond intelligently to questions offered by his own attorney, but also to the questions that were asked by the attorneys for the state. So it wasn't simply an ability to answer questions that he had been thoroughly prepared for. He was able to answer questions that, he would have been—
General Redding,
Yeah.
I don't mean to cut you off. Have you addressed why he was interviewed without a parent present?
In my, not yet, but so defense counsel is correct. We have the information we have about his mother taking him to the juvenile detention center is in the transcript from the motion to suppress hearing. It's fairly brief. His mother testified that she took him to the detention center. She talked to somebody and said, "Don't talk to my son," and that she then left and went to work. So it is fairly limited. We do have some information that comes out, I believe, at trial about the offense happened. The defendant was on the run for 3 days. His parents were very aware of the fact that law enforcement was looking for him. They believed law enforcement was watching their house and his grandmother's house. So his mother was well aware of the situation, but in terms of her son being a person of interest, and when she took him to the juvenile detention center, but it's fairly limited, but it's not disputed that she did tell the detention center folks not.
So why did the state interview him without getting the mother back up there?
That is not clear from the record. All we have is that the mother dropped him off and went to work, but I don't there's nothing in the record about.
Well, is that acceptable? Is that all right?
It is. I mean, I don't think that it's ideal, but this court has found that this is a totality of the circumstances evaluation, and that the admissibility of Juvenile's confession isn't dependent upon the presence of his parents and an interrogation. And as to the defendant's mother saying, "Don't talk to my son," the issue with that is that the defendant is the one who holds the rights. He is the one who has to invoke his right to remain silent, has to invoke his right to an attorney. His mother can't do it for him. So
But it's troubling to me, General, and I apologize for interrupting you. It's just inherent in the Zoom process. But what's troubling to me about this is we have clearly some intellectual deficiencies combined with the youth of the defendant. Then on top of that, you have a parent that's basically exerting herself, into the situation and saying, there's a reason why you shouldn't talk to my son. And I guess I am troubled. I'm not sure exactly with all three of those things, how the defendant could be seen as, understanding his rights and I guess waiving those rights. And I also wanted you to address, I apologize for being fragmented, but with expert testimony, how do the trial courts treat that combined with all of those three things that I just addressed?
So this case is interesting. Well, I think I'll first address the court's concerns about the totality of the circumstances. I think the defendant is 15 years old. He does have some learning disabilities, but we have conflicting information about his IQ. We have information showing from the school saying his performance on the test that they conduct, which is strongly correlated to a full IQ test, that his performance on that was average. So he does have a learning disability, but he does not have an intellectual disability, and he has an IQ score that puts him on an average plane. And that is in the record for this court.
Does he have the mentality of an 8 or 9 year old or not?
It's a state's position that he does not, that his IQ test puts him in an average, on the lower end of average, but that his learning disability does not mean that he didn't understand what he was doing, that he could not knowingly and voluntarily waive his Miranda rights. And that really it's connected to the defendant's statements and his reactions and what he said during the interview. And this is not a defendant who didn't understand where he was, didn't understand what he was doing, didn't understand why he was being questioned. This is the defendant who, yes, did have some learning disabilities, but was able to understand his circumstances, was able to understand the circumstances of his interrogation, was able to understand what it meant to have an interrogation, to answer questions, what could happen, that he could end up going to jail for life. And he had the faculties to describe what his own actions were, to develop a story, to convey this story to the law enforcement officer. So despite his learning disabilities, despite his lower than average IQ, these are still factors that show that he was able to voluntarily and knowingly waive his Miranda rights. This is not a situation where the defendant just was not mentally capable of getting it.
Well, I mean, that's what we're trying to determine. I mean, I understand you saying that this is not that situation, but this is a lot more than I've seen in terms of before in cases where you've got expert testimony evaluating the defendant. You've got the age of the defendant. You've got clear learning disabilities or in intellectual deficits. And you've got a parent who basically puts the state on notice of these things. So I understand your position, but it is troubling.
Well, and I'll say, as the parent, I mean, that it is concerning that she told somebody at the juvenile detention, don't talk to my son, but she does not have the ability to invoke her son's right.
I understand, but we are under the totality of the circumstances here, and that's a big factor in my view.
I'll also say too, as to the expert testimony, this was not, this was presented at the at trial rather than at the motion to suppress hearing.
Are we not allowed to consider that? I mean,
you are, but the trial court did not have it before it when it made its original ruling. But as to the testimony that was offered by Dr. Brown, who was the one who conducted the later kind of intellectual assessment, she even admitted that the defendant scored, she said that he had scored a 78 on her full IQ test. That is above the 70 threshold. And she admitted that his daily drug use could have affected his IQ test, his performance on the test. It's undisputed that the defendant admitted, I believe, that he started smoking marijuana daily and I think all day at a fairly young age. So that could have affected his intellect there. But she admitted as to the Miranda warnings, there is no evidence that the defendant had prior run-ins with the juvenile system, but the defendant's own expert admitted that she performed a test, or she conducted a test that's designed to analyze how the defendant, his understanding of Miranda warnings and his understanding of what those warnings mean, and that the defendant not only showed that he understood the Miranda warnings, understood what they meant, but he also scored consistently or a bit higher than other individuals his age. So that is something that this court should consider, that the defendant's own expert had to concede that her testing showed he understood the Miranda warnings. And I think that's consistent with the defendant's statements that he made despite his intellectual disability, his learning disability, not intellectual, but his.
Sorry, that was my fault for injecting that as well. But go ahead.
In a closely related term. But I think based on the totality of the circumstances, if you consider, even with the absence of his parents, if you consider what the defendant said, how his understanding of the Miranda warnings and the sophistication of his statement, the totality of the circumstances show that he knowingly, voluntarily, and intelligently waived his Miranda rights and gave a statement to law enforcement that was properly admitted. As to the defendant's claim regarding the eyewitness identification, the defendant is not entitled to relief on this particular claim. The defendant's full claim on appeal is that the eyewitness identification was unreliable, but a court doesn't have to consider the reliability of an identification unless it first finds that the identification procedure was improper. Because the defendant failed to argue, much less show, that the identification procedure used in this case was unduly suggestive, or that it created a substantial likelihood of irreparable misidentification, he can't show that he's entitled to relief. Regardless, the record supports the trial court's conclusion that the identification procedure was not unduly suggestive. First, the lineup was created by the juvenile court, not by the interviewing detectives. Second, the trial court found that the lineup contained 6 images of similar looking individuals, and there's nothing in the record to contradict the trial court's finding. And frankly, the image that's included in the appellate record would not allow this court to conduct its own review on this particular factor because of the quality of the image. Third, investigator Cook, who's the one who conducted the identification procedure, just asked the witness to look at the lineup and report if anyone he recognized. And the witness immediately identified the defendant. Even if this court were to find the identification procedure unduly suggestive, the defendant's not entitled to relief because the totality of the circumstances shows that his identification of the defendant was reliable. First, the witness had a significant opportunity to view the suspect. This offense occurred in broad daylight. The defendant walked across a parking lot. The witness saw him do this. The witness saw the defendant approach the car and then sit with him in the small backseat of the vehicle. Second, the witness was paying close attention. He recalled the details of the defendant's approach to the vehicle, recalled the defendant entering the back seat, and then pulling out a weapon. The defense has made much of the fact that the defendant had a gun, or the perpetrator had a gun, and that this gun would have distracted the eyewitness, and the eyewitness would have looked more at the gun than at the person holding the gun. But this is a situation where the witness had an opportunity to view the defendant without a gun being involved. The defendant did not just appear at the side of the vehicle with the gun. The defendant walked across the parking lot, got into the back seat of the car, chatted for a minute, and then went to, the witness thought he was getting money out to pay for the marijuana, and that is when he removed the gun. So that is, the introduction of the gun comes later after there is an opportunity to view the defendant's face. The witness paying close attention to details and said he remembered the details of the defendant's approach to the vehicle, but he also recalled the details of being shot. He recalled the details of being shot in the head, turning and confronting the defendant and saying, "Did you just shoot me?" And the defendant shooting him again a second time in the face, and then seeing the defendant shoot his brother. And he recalled the details. He remembered, he shot my brother as they were fighting over this bag of marijuana. So we have a witness who's paying close attention, who has not been distracted by the immediate appearance of a weapon. Third, the witness did not give a prior description of the defendant. Although the witness did say that he didn't know who shot him, what he meant is, I don't know this guy's name. I know the other person's name. He identified the accomplice, the defendant's accomplice, because he did know that person from the Facebook interactions. So he was able to identify the second perpetrator by name. He just didn't know the defendant's name. And there's no evidence in the record that the witness saw a photo of the defendant's face before making an ID. There's a photo of the fake money, but my recollection, and the photos in the record, so this court can review it itself, but I don't believe that there are any faces in that photo. So the witness was familiar with Mr. Norbert's face, or Norbert, but not with the defendant's face. So the fact that he wasn't able to identify the defendant by name immediately does not have any effect on the validity of his identification. And
You have about a minute left of your time.
The witness demonstrated a strong level of certainty in his identification. He didn't give a confident statement, but the officer testified he identified the witness with no hesitation. And the confrontation occurred, the eyewitness identification occurred 4.5 hours after the shooting. So there is not a long delay. The defendant was identified at the hospital. This victim clearly had been obtaining medical treatment for the 2 gunshot wounds to his head prior to the identification. And as a result, the defendant is not entitled to relief on his claim regarding the eyewitness's ID. So if there are no further questions, the state asks this court to affirm the judgment.
Thank you. Rebuttal? You're muted.
Sorry, Judge. I guess it has to happen eventually. If the court please, I'd like to highlight just 2 points. One is that the IQ testing done by Dr. Brown, I'd ask that the court consider that to be more reliable than the school's testing. We don't know very much about the provider who did the school testing or the purpose for which that was done. We know that Dr. Brown is extremely well thought of in her field. She's in charge of the forensic program at Vanderbilt. And I mean no offense to whomever did the testing for the schools, but we know much more about her qualifications, Dr. Brown's qualifications, than the other expert. And the second thing that I'd like to point out with respect to the presence of a parent or interested adult, this was a case where they could have had her come back. If they wanted to, they could have called his mother and said, "The detective's here and wants to talk to your son. Can you come back?" And they didn't. And I think that we suggest that should be something to be considered. The difficulty with the state's assertion that he holds the right is that we must recall that he is a child. And there's a cutoff at some point where the child may hold the right but not know what to do with it. And that's the important part. So for those reasons, we ask that you reverse. Thank you, Your Honors.
Thank you. Appreciate your arguments.
The Honorable Court is now in recess until 1:30 p.m.